Yeah, I can hear you loud and clear.
All right, thank
you. Yeah, good evening and welcome once again to our platform, Zoom Entire Association, which is our programs are always live via Zoom and then SARKI TV on YouTube.
Thank you, my brother.
So just a quick announcement. Today, we are grateful again to have our own brother to lead us in this particular session, which is termed Legal Hour with Lawyer Wisdom of Wise Smart Solicitors in London. So we will have about 40 to 50 minutes of lecture and then followed by a question and answer session. So I know a lot of people have been asking questions from your last lecture to date. So hopefully they will seize the opportunity to ask questions. As I keep advertising and then encouraging people to join us, we say this is free legal service, which is very rare to come by. So we are most grateful to you for this opportunity. So once again, you are welcome, and then you may start.
Thank you very much. And to everybody on the platform, this very beautiful sunny evening out there.
That's it.
We're all out having some barbecue and then, having some, this is where we are.
That's it.
Okay, I was going to use my laptop, but it seems not working well. So I'm using my phone. So if there are any hitches, please let me know that I can quickly make amends. But you can hear me.
Yeah, we could see you clearly and hear you clearly as well.
Yeah, right. The last time we spoke, we discussed about the 20-year long residence thing, about the different ways a person who has been in the UK for 20 years could possibly get their right to be in the UK. And we discussed about things that as to the documents we're going to use and all that stuff. So we did discuss, it was general and then questions followed. Today, I would like to just, first of all, say, if you are an EU national or a family member of an EU national and you still haven't registered for the settled status or the pre-settled status, please, 3 times, make sure you register before the 30th of June. Otherwise, after 30th of June, you would have to give a good reason why you could not register before the 30th of June. And you are leaving it at somebody's discretion to decide whether your reason is good or not. But if you register, if you apply for the settled status or the pre-settled status, you are covered. If you're an EU national or a family member of an EU national and you get your settled or the pre-settled status, you are covered. In fact, even if you apply and the decision hasn't come yet, you are still safe because you applied before the 30th of June, 2021. So please remember that. Let's all keep that in mind. The next thing is, if you know anybody who has applied for EU family permit from Ghana or anywhere in this world, Nigeria, anywhere outside the UK, the person is an EU national, they've applied for their spouse or their child to come and they have already given it to them. They have to get to the UK before the 30th of June. Otherwise, they will have to make a fresh application before they can come. So if they have already been granted, they should make sure they enter the UK before the 30th of June. If they don't get here before the 30th of June, then they have to make another application under the EUSS. What I'm talking about is a EU family permit. If they've given it to you under the EU family permit and you are not here before the 30th of June, you have to make application under the EU family settled status. So there are two things, the EU family permit and the EU settled status. The settled status takes effect from the 30th of June. So if a person already has visa or entry clearance under the EU family permit, they will have to change it to EU settled status. before they can travel to come to the UK. I will say that again. If the person already has visa or entry permit under the EU family permit, they will, and they don't get here before the 30th of June, they have to go online again and make another application under the EU settled status, changing from the family permit to the settled status before they can travel to the UK. To avoid all of that, just make sure, even if you have to go and borrow money, make sure you borrow money, they get here before the 30th of June. Otherwise, if you go and apply, excuse me to say, some crazy person somewhere can just decide that you don't qualify and they will not come. To avoid all of that, they should just ensure they get here before the 30th of June. If they have already been granted the 6 months EU family permit, they should get here before the 30th of June. Those that have applied and they have not been granted, regardless of whatever time they give them, they can still not travel to the UK. They will have to apply again to switch to the EU settlement scheme before they can come to the UK. So I'm talking about two things here: family permit and settlement scheme. From the 30th of June, the settlement scheme takes effect. Before the 30th of June, the family permit is effective. So if you have it under the family permit and you don't get here before the 30th of June, you have to change it to the settlement scheme before you can travel to the UK. Very, very, very important. Very important. So please let anybody who is in this position be aware. Otherwise, they will find a lot of difficulties. So that is a bit of information for all of us. The other thing before I go to my main topic is, if you know anybody who is on 2.5 years limited leave to remain and they are having financial problems, meanwhile, the law says there is no recourse to public funds, which means they cannot take any benefit, let them apply for the government to remove that no recourse to public funds, and then they can take all the benefits that they are entitled to: housing benefit, child tax credit, everything. Once the government removes, once the Home Office removes that no recourse to public funds, they can take any benefits that they are entitled to. But as long as that no recourse to public funds remains on your card, you cannot take any benefit. Even if you are dying, you cannot get any benefit. Especially our mothers, our sisters who have children and they are going through a lot of difficulties. I say it is a free of charge application. You don't pay anything to the Home Office. All you do is go online, get the right form. It's called change of condition. That is the name of the form, change of condition. You complete the form, put your information there, let them understand why you cannot feed yourself. Or maybe the money you earn, maybe at the end of the month you get $750. Meanwhile, your rent is about $300. It's left with $450. Your food, your hairdressing, salon. You talk about travel. You talk about stay. You talk about what do you call it? Other utilities. The money is finished. If you add up all that you spend about 1,200. Meanwhile, all you receive is 750. It means you have to borrow from other people to live. That is a clear example of somebody, when you present your case, the Home Office will remove that no recourse to public funds, and you can then apply to the council and they will start giving you benefit for you and your child to live. Again, it is a free of charge application. You do not pay anything. But of course, you can do it yourself. But if a lawyer does it for you, the lawyer will certainly charge for the administrative cost, the time they spend and everything. But you don't pay a penny to the Home Office for them to remove that condition. That is a free of charge application. And another one too is called fee waiver. Fee waiver. I don't know if I've mentioned this before, but what it means is, if you have 2.5 years to be here, again, our mothers, our sisters, and mostly as for the men, they don't even mind us. They know we can go and work. But it is the women that normally, because they have the kids, they are very compassionate towards us, our mothers and our sisters. If you cannot pay the application fee and the home and the IHS is 1,560, and the application is 1,033 pounds, and then you pay biometric fee of 19 pounds 20, and then you pay the booking of the appointment to around 122 pounds. In total, you are around 2,000, very close to 3,000 pounds alone, one person. If you are two, you are already getting into 6,000 pounds. If you have 3 children, you know you can do the math and the multiplication. If you cannot do that, if you don't have the money, what you have to do is apply for fee waiver. Fee waiver. The first one I talked about is called no recourse to public funds. That is for benefit. Fee waiver is the fee you are supposed to pay. You are asking them to waive it. In other words, they should take it. They should chair you. They should in other words, you don't have to pay. How will you say that in our language? So that you don't have to. It's like free of charge.
Yeah, temoko, like a help.
Okay, like help. Okay.
Yeah, temoko.
Temoko, yes. So you can't afford, so you are asking them to let you apply without paying that. The last one I did for as a family of 4 children was over 10,000 pounds. They did not pay a dime because one, their father is not in the UK, their mother is here, but she is not well. She has got some medical problems, and there is no way she can work to pay for herself and the children. So when we applied, the Home Office waived off all the fee for them. Over 10,000 pounds, they did not pay any amount. So my dear sisters who are listening, or if you know somebody who is in such a position, please don't keep quiet and suffer, or don't let your visa expire. Don't let your leave expire without you renewing it. Apply for the fee waiver. That is also a free of charge application. The Home Office does not charge for that application. If you can do it yourself, do it. You don't pay anything. If they grant it for you, they give you a code. You use the code to make the main application. There's 2 applications. The first one is that you don't pay. Once that is granted, then you go ahead to do the main application, and you use that code to make you enter the code in the payment section, and then it just waves you off. You don't have to pay anything at all. You don't pay anything. It's free of charge. You can do it yourself. You don't have to use a lawyer. If you know what to do, you can do it yourself, nothing to pay, and you can get away with that, paying all of that. Right, thank you very much. So today I just want to briefly talk about how to switch. People who are on the 10-year route want to switch to the 5-year route. How to do that so that you don't have to remain here on the 10-year route. Especially our mothers, fathers who have been here for 20 years. Now that things have started, the 20 years applications, we are now able to start submitting them. So if there is anybody you know who has presented a 20-year application, from now onwards, we are able to submit it. There was a break, there was a block, but now the windows are open, so we can start submitting those applications. Now, if you were here for 20 years and you have been given 2.5 years on the 10-year route, if you don't switch, you will remain on it for 10 years. So 10 years plus the 20 years you have already done, that is a total of 30 years before you get your indefinite leave, by which time you have expired. If you're not careful, by the time you get your indefinite, there is no strength to do anything again. There are ways you can switch. So that is one. And also people who are here as a parent, maybe you were here, you have a child, you didn't have any visa or leave, and then you applied, and then they gave you 2.5 years on the 10-year route. You can also switch. That is also possible. Or you married, and when you married, they gave you the 2.5 years on the 10-year route. That is also possible that you can switch to the 5-year route. Or a person who has been granted 2.5 years on the 10-year route under Article 8, family life. Maybe the person has some serious medical problems, and because of that, they gave the person 2.5 years on the 10-year route. it is also possible to switch. So, or somebody who is here as a student, you came here as a student, the first 2 years you were here. You don't want to be here for 10 years before you get your indefinite. And therefore, it's also possible to switch. How do you do that? Number one, you can switch by marrying. If you marry, that is for partners. If you marry, assuming I am on the 20-year, I did the 20 years, I've been given the 2.5 years on the 10-year route, and I marry today, I get into a relationship, the woman is a British citizen, or the woman has indefinite leave, and I marry her now, although my 2.5 years is not finished, maybe I have done only 6 months on the 2.5 years, I can make a fresh application to switch from the 10 years to the partner route. That will be the 5 years. So I'll do 2.5 years, and after that, another 2.5 years, and then I go for my indefinite. Whereas somebody is waiting for the 10 years to get their indefinite, once I marry, maybe we all did the 20 years and we got the 2.5, 2.5. I have fallen in love, I have a partner, I can switch to the 5-year route. After 5 years, I get my indefinite when he is still waiting for 10 years to get his indefinite. So that is one way it can be done. So if you get married, it has to be to a British person, someone who has got British citizenship, somebody who's got indefinite leave to remain, permanent residence card, or somebody who is settled in any other category, maybe as an asylum seeker, and eventually they gave him indefinite, then you have to be in relation with somebody like that. If the person has 2.5 years, you cannot switch because the person themselves is not settled. So you cannot switch from your 2.5 to another 2.5 person. That will not work. So that is one. The next one is, before you can switch as a partner, there are some requirements. You have to show that, before I go there, the 5-year route, it does not mean they will give you all the 5 years at the same time. No, they'll give you 2.5 years and another 2.5 years, total of 5 years. The one you have done on the 10-year route, you will not add it to the one you are starting. If you're on the 10-year route, you either finish the 10 years or you start the 5-year from the scratch. So if I am on the 10-year route and I've done 6 months and I apply to switch to the 5-year route, I'll have to start the 5 years from the beginning. So it is 2.5 and another 2.5. So if I add it to my old one, it is 5 years, 6 months, I'll get my indefinite leave. But if somebody is on the 2.5 and decide they just relax, they don't really mind, and they wait until 2 years before they start the 5-year route, remember the 2 years they have already done is gone waste. You cannot add it to the 5-year route. So you have to start the 5 years again. You do another first 2.5 and another 2.5, 5 years. If you add it to the 2 years, 70 years. When somebody has done 5.5 and they are getting their indefinite, somebody is doing 7 years or 7.5 before they get indefinite. No, so the quicker you do it, the better, rather than wasting that time. The time you have spent on the 10 years will not be added to the time you are going to spend on the 5-year route. So that is something I want us to be very mindful of. I had my own cousin, I did it for him. And I told him, my brother, let's switch. I have to switch you. This thing has to switch. If I when he got the first 2.5 years, he was too happy. He forgot about everything. Before he realized the 2.5 years had passed, before he came for me to switch it for him. By the time he finishes his 5 years, in total, he has done 7.5 years because the first 2.5 years is waste. So the earlier you do it, the better it is for you. You save yourself time. Nobody is growing younger. We are all growing older and older and older. Every day we are growing up and growing old. So we have to save as much time as we can so that we can have some time to enjoy our lives before the D-Day comes. We don't want to work until the day the Lord calls us. So please let us save as much time as we can. Let us save as much time as we can. Now, what are the requirements? If you want to switch to the partner route, there are two things, partner route and parent route. I'm not talking about the partner route. there has to be something we call RIFE, relationship. You and your partner will have to show that you are in a genuine relationship. Either you are married or you've lived together for 2 years. Either you are married or you've lived together for 2 years. If you are married, we need a marriage certificate. If you've lived together for 2 years, we need evidence of cohabitation for 2 years. Now, you also have to show that your visa is still valid, it's not expired. If your visa expires, you cannot go to the 5-year route. You'll still be on the 10-year route. So you always have to do it whilst your visa is still valid. So the R stands for relationship, the I stands for valid visa or immigration status. Then the next one is the financial requirement. If you are married, you have to meet the financial requirement. We treated that some time ago, the 18,600. If there is any child involved, then you have to add 3,800 for one child. If there's another child involved, it is another 2,400. But if the children are British citizens, you do not add the 3,800 and the 2,400. If the children are British, you do not add the extra monies. It's only the 18,600. Then you also need to meet the English language test. The English language test. You have to provide level A2, level A2 to show that you made the English language test. Otherwise, the application will be refused. If the application is refused and probably you don't appeal, they will tell you, the Home Office will tell you to start reporting to the Home Office. There's a place in Croydon called Electric House. When you go, they will electrify you if you're not careful before you realize you're in Kotoka. So please, 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 let's try to avoid that. There is one at London Bridge. Also, they have been reporting there. There's one at Croydon called, I don't know why they call it Electric House, because that's the Croydon one is called Electric House, and then one also at London Bridge. If your visa is expired, you go and apply and they refuse you, they'll ask you to start reporting. One day you will go, they will tell you, wait, let's interview you. Before you realize, they tell you you have overstayed. If you are not careful, the next available plane to Kotoka, you will be on it. Or even if you don't want to go, before the lawyers will get you out, you would have spent money which you could have used for something else. Money that you could have used for some project somewhere, you'll be spending it on with the lawyers because you waited until your visa expired before you went to apply. Let's avoid that. It's not reasonable for us to keep wasting money and time. So please always make sure you apply whilst your visa is valid before you can switch. The next thing is you must have the English language test. I talked about that, level A2, or you have a first degree. You have a first degree, or you have a degree which NARIC, UK NARIC, NARIC, UK NARIC will have to certify that, well, you have a degree and it is acceptable as a valid degree in the UK. With that, you are able to apply. You must also have accommodation. Accommodation. So I've talked about RIFEA. That is accommodation. The accommodation stands for you have to have a tenancy agreement or a mortgage to show that you have a place where you and your partner can live without overcrowding. Now, when we talk about accommodation, we are guided by the Housing Act of 1996 in this country, the Housing Act of 1996, Part X. Now, there are some houses that there are too many people in the house, and that is overcrowding. This country, they don't accept that. One room is for 2 people, 2 rooms for 3 people, 3 rooms for 5 people, 4 rooms for 7.5 people. 5 rooms and above is 2 to a room. Now, somebody will say, who is a half person? Half is like a child beyond 10 years is regarded as half. A child under 10 years is regarded as 0. So that as for a child, they can live with their parents or anything. So they are regarded as 0. After 5, after 10, they are considered as half, more or less. So that is it. 1 room, 2 people, 2 rooms, 3 people, 3 rooms, 5, 4 rooms, 7.5, 5 rooms, 2 to a room. And that is under Part 10 or Part X of the Housing Act of 1996. We can all go there and read it. The table is there for us to see. You can all see that. So that is where we are. Now, once you meet these requirements and you apply, you will be switched from the 10 years to the 5-year route. You don't have to be on the 10-year route. You need your passport, you need a birth certificate, pay slips, bank statements, letter from employer, and proof that you have actually lived together as husband and wife. With that, you'll be granted, you'll be switched from the 10 years to the 5-year route. After 5 years, 2.5, bingo, you go for your indefinite leave to remain. I will briefly talk about the parents. The parent route is different from the partner route. The partner means you have a partner, wife, or you're in a relationship. Parent means you are living in Dagenham, the woman and the child are in Dawson Junction, but you have contact with your child. And because you have contact with your child, you are not married to the child's mother, no. You are not living with them, no. But you come, you see your child, you pick the child out, you take the child to school, the school gives you a letter, the GP gives you a letter to show that you are involved in the child's life. Not that you have just given birth and left the child like that, but you are involved in the child's life. In that case, you can also switch from the 10 years to the 5-year route. But in that case, the child, the mother with whom the child is, must have indefinite or British. Because if the child's mother also has 2.5 years, they are not likely to switch you to the 5-year route because the child's mother is not settled. But if the child's mother is British or have indefinite, then you, the father, who is having the 2.5 on the 10-year route, you can also switch to the 5-year route. Again, you have to show something we call the relationship rife. Relationship, you and your child must have a relationship. I keep saying you don't just give birth to the child and leave the child. Sometimes the men are guilty of this a lot. We just give birth and leave the child. When we want krata, they will go and be hustling the woman to let us have access to the child. It is not good. Let's be fathers. Let's play our part as fathers. It is a very dangerous thing because today you and I, we have strength, we are running about. Tomorrow when we are old men, we need the children to come and even call you to say, Daddy, how are you? They wouldn't even mind you because you were not there. And that alone can even kill your spirit. So let's be involved. This is advice for my brothers. Let's be involved in the children's lives so that even when we are old, even if they don't bring us money, the fact that your child can even call you to say, hi, Dad, how are you? I just passed and just want to see how you're doing. That to me is even satisfying enough. It's satisfying enough. So there has to be some relationship. Take them to school, pick them from school, GP you are involved, the GP will give a letter, the school give a letter. That is evidence of relationship. The woman must also write a letter. The child's mother will write a letter to say, oh yes, we are not together, but the man is very much involved in his child's life. He picks the child, he plays a role, he takes the child to the park. If you are not good to the woman, the day you need the letter, you yourself, you will see something. They won't give it to you, I know, because sometimes I literally have to beg on behalf of some men because they are not doing what they are supposed to do. So please, my brothers, the women, they don't really want too much, just something small, just make them happy. And when you need a letter, they'll be more than happy to give it to you to show that you are involved in the child's life. Then you need the immigration again, your visa shouldn't expire. You need maintenance. This time you don't need the financial, you need the maintenance. Because it's a child, you are applying based on maintenance, not on financial. So no 18,600, no. But you need to show that as a single parent, you have 74 pounds, I wrote it here, 74 pounds 70p a week. 74 pounds 70p a week. If you multiply it by 4 weeks, it's 298 pounds a month. And for the child, it's 68 pounds 60p a week times 4 weeks. That gives us 274 pounds 40p a month. If you add the two, we get 573 pounds 20p a month after your rent and your council tax. So if your rent is 300 and you add it to 573, you are looking at 873.20, and maybe your council tax is inclusive in the rent, or it is even 100. If you add that to it, it takes you to 973 pounds 20p. Once your pay slips show that you meet that amount, you made the financial requirement, you made the maintenance requirement. I'm sorry, you made the maintenance requirement. You are okay. The next thing is English language requirement level A2. You have to do that as well. And accommodation. Again, 1 room for 2 people, 2 rooms, 3 people, 3 rooms, 5 people, 4 rooms, 7.5 people, 5 rooms, 2 people to 1 room. Now, if you are living in a place where you don't have a room to yourself, if you want to switch, that can be a difficulty. So it's always better to have a tenancy agreement, or even if you're living with somebody, the person has to give a letter plus a copy of their tenancy agreement to say, look, there are 4 rooms in this house. It's just me and this gentleman. There is more than enough room for him and the child when the child comes to visit. Now, with this, I can assure you that when you apply, you'll be switched from the 10-year route to the 5-year route. Then, after 5 years, you go for your indefinite. Thereafter, you will be eligible for your British citizenship once you meet the good character requirement. So briefly, this is just something I want to put, then the questions can flow and then we can take it from there.
Yeah, thank you very much. Thank you very much for this very enlightening aspect of it. Yeah, I know people have questions, and then just to announce, I have advertised Lawyer Wisdom's contact telephone number on the chat. So whoever wants to make contact after this program could please pick up the number and then contact Lawyer Wisdom directly.
Thank you.
There is a question sent out to me here to be asked on behalf of one of our listeners. Is that a child was born in this country at the time the mother was married to an EEA citizen. But in the process, she happens to have a child with another person who is not resident in the country. So she did not put the name of the EEA, national on the child's birth certificate. But currently the child is in Ghana. Since the birth, she sent the child away to Ghana. So now, will she have to, what is the process of registering the child in the UK at the moment?
Okay, thank you. Now, has the parents got the indefinite yet? Has the mother got indefinite?
Yeah. The person just got indefinite.
Perfect. Perfect. And how old is the child in Ghana now?
The child is about 10.
Perfect. This is excellent news.
Okay.
Now that the parent, first of all, the child was born in the UK. That is the first news. So the it shows. Number 2, the mother has got her indefinite leave to remain.
Yeah.
So this application will be made under the British Nationality Act of 1981, which says a person born in the United Kingdom, whilst a child, an application is made for that person, and the Secretary of State deems it reasonable that that child should be registered, the child will be registered as a British citizen. So in this case, we are not applying for visa for the child to come. We are applying for citizenship straight away for the child. It will be done here in the UK. The child's British passport will be issued in the UK. It will be posted to them in Ghana, and they can travel. The child will travel with a British passport. When the child gets to Kotoka, the child will wave the passport and say, la, 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 la. They will wave. So it will be done under Section 1(3) of the British Nationality Act of 1981 for British citizens.
Okay. So I think that is pretty straightforward. So it's just the registration and then under the act. Okay. All right. That's good.
The fact that there is no father's name on it is not a problem. But my answer is, the father of the child, is he in this country? If he is,
he is not.
Okay. All right. If he was here, what we can do is, as soon as the child comes, the child with their British passport, the father will do the DNA, put his name on the birth certificate, and then bingo, if he has got to stay, he also gets to stay.
Okay. So at the moment, there wasn't a father's name on the child's birth certificate. So is that still okay just for the mother to do the
100%?
Okay.
The mother, go ahead. Yeah.
All right. Thank you very much. Thank you for that very detailed explanation. We've got two hands up at the moment. Safu, is it Safua? Can you please unmute yourself and ask a question? Yeah.
Yeah, it's Safwa. Sorry, I'm Safwa's sister. I'm here with Safwa. So my name is Naomi. I'm joining. I just want to ask a quick question. So I've got indefinite leave. Mine is permanent. It's not indefinite. It's a residence. I was a EEA national family member, and I've got permanent residence permits, which is 10 years. It was given to me in 2013. So I actually qualified for naturalization the year after, but I've kind of delayed. But because of this, we are leaving the EU, I'm a bit worried. So I've started the application online. My question is, do I still need to do the settlement, or should I just do my naturalization and just get on with it?
Have you done the life in the test?
I've done the life in the UK. I did it in 2015, and also I did a degree in social work a while ago. So I've got.
I would still say, if you want to do the application now for the citizenship, then go ahead.
Okay.
But if it's something you're going to do after June, then please do the settled status application.
No, I've actually started the naturalization application. I'm almost done. I think I'm got to where I have to make the payments.
Then go ahead quickly and don't.
If it goes through, because I was just thinking, should I do the settlement and come back? But it will be of no use because I'll be doing a naturalization anyway. So I've chosen to do the naturalization.
Yes, go ahead with the naturalization. And once you get because even if you do the settlement and they give you the card, right?
Yeah.
And go ahead to do the naturalization, you still have to put the scissors through the card and send it back to them anyway.
Yeah. Okay.
So once you are eligible for the naturalization, you have all the required documents. You've met the good character requirement of being here for 10 years lawfully. Please go ahead, submit it, and then it should be considered, right?
Okay, thank you. I've got a second question for my sister Safwa. The question is, she's married to an EEA national.
Right.
They did the application in 2018, and they got refused. They went for an interview actually, and they got refused. There were some discrepancies in the questions. We've been through court, I think 3 or 4 times. We've been through, the upper tribunal, and they all keep using the very first decision the Home Office made. The lawyer who is handling the case is going to do another application before the 30th of June. And I think we just wanted to find out what our options are, because I've read around the rules and, the regulations guiding, I think with the law, if you say you are married, they will have doubts about it, but they cannot, sort of dismiss it, entirely. And I think we were not sure, although the Home Office have not made any steps to, when they've refused the application a number of times, they've not asked my sister to go.
Leave the UK,
leave the UK, because the husband lives and works here. He's done the pre-settled, is it pre-settled scheme? Yeah. So he's done everything. He's still working. He's got his tenants. He's got everything. The only thing that they sort of stood on and refused them was the fact that they gave conflicting, answers to the interview. So is there any way out?
No. The problem is, before they would invite anybody for an interview, the caseworker already has a suspicion that this relationship is probably not genuine. That is why they want to clarify before they make a decision. So when anybody goes to the interview and your answers are conflicting, it only goes to confirm what the caseworker already thought. Now, if you've been to court the first time, second time, upper tribunal, and they are all referring to probably the inconsistencies in the interview record, which is casting doubt on the genuineness of the relationship. There is this case called the case of Divarsilan. Now, that case is a court of appeal and case. It says, when you go to court, the judge who is sitting on your case today will have to look at the previous decision that was made in your case to see if there's something significantly different from what you are brought to court today. So if you've been to court last year, they refused your application, you went to court, and then this year you go to court again, the judge is bound by the case of Divarsilan to go back and see what the first judge wrote before he can make his decision. Now, the record is with the Home Office. I will say they should go ahead and make the application. If it is granted, thank God. If it is not granted, they have the option of administrative review. If the administrative review is refused, they have the next option of going to court again. Then they can then put their case across in a different way and say, look, the fact that we made errors in the first time does not mean our marriage is not genuine. If it was not genuine, we wouldn't keep together for all these years, maybe 3, 4, 5 years. And of course, the fact that we gave different accounts doesn't mean we are not credible. People remember things differently. Women remember things into more details than men do. If you ask a man, what did you eat last weekend? He doesn't care. He was hungry. He has eaten. He's satisfied. He doesn't care what he ate. If you ask a woman, what did your husband eat last weekend? She will give you the details, the number of fish she put on the rice. She will give you the details. The fact that the man hasn't given the details about what he ate doesn't mean that he was telling a lie. So when you take it to court, then you make the judge understand that people remember things differently. The fact that we gave a very, very minor conflicting report doesn't mean that the relationship is not genuine. So I would say they should go ahead, but they should have a very open mind that it can be refused, and then they can take it on the legal route. That is my.
Thank you very much for the clarification. The other thing is, what would if they are expecting a baby or they plan to have a baby, would that change the outcome?
That would change the dynamics, because if they were not actually in a genuine relationship, how would they have a baby? So that's the very major factor in their favor. So if they are planning to have a baby, I'll say they should start working from tonight. And if they are
you've made me laugh.
Yeah, so that can change everything in their favor. Okay.
Okay. Thank you very much.
You're welcome. You're welcome.
All right. Thanks very much. Thank you. Thank you, Lawyer Wisdom. I think our next questioner is Ibrahim Musa. Could you please unmute yourself and ask your question?
Hello. Good afternoon.
Yes. Hi. Afternoon. Evening.
Yeah. Good evening. Sorry. My question is about the parent route.
Yes.
Yeah. For instance, if you live in Dagenham and your wife living in Enfield, normally you work Monday to Friday. So that means you have no access to go and visit them during the weekdays. Normally we visit them during the weekends. So that means you don't have no access to go to the GP or to school. There is any evidence that they can give you to show to the Home Office that, oh, look, due to this, you don't have it. There's any possibility you can got that reference?
Okay. Evidence? Thank you. Are you talking about the parent route or the partner route?
Or the parent route, that's correct. Parent.
Yes, if it is a parent route, I will say no matter what you do, no matter how many hours you work, no matter how much money you give to the kid, you still have to have some kind of contact. Now, although you work Monday to Friday or more, you don't have contact, the GP wouldn't write anything like that because they haven't seen you. The school wouldn't write anything like that because they haven't seen you. So this is what I would advise. Let your name be in the school as the father, even though you may not be able to drop the child in school every day and pick the child every day. When it comes to parents' evenings, please
take time off.
Yes, take time. That is only once in a while. Attend.
Yeah, but what? Sorry, but the child is. Let's take it. The child is 2 years, so he didn't start schooling for now.
Well, if the child hasn't started school, then the only option you have is a GP. Then make sure your name is at the GP as the parent. And when the mother is going for any GP appointments, if I were you, I will go there. I know these days they don't allow parents, 2 people to enter. I'll be at the entrance. And then the woman, the child's mother, will write a letter that although the man is involved in his child's life because of COVID-19, whenever we go for GP appointments, they do not allow him to enter. Bingo, you are covered.
Okay. Okay, that's correct. Thank you very much.
You're welcome.
All right, thank you very much. Thank you for the answer. So we are still with Lawyer Wisdom. In case you have questions, I've not seen any hand up at the moment. Please do ask your questions. I know a lot of people are waiting to make contact after the lecture.
Question.
Okay.
Good evening, lawyer.
Good evening, my brother.
Let's say you've applied for like naturalization, but maybe before the 30th your card expires and the naturalization hasn't come. Do you have to apply for the settled status?
Once your application for the naturalization is in, fine. Your visa, your leave carries on continuously until the decision is made. But sometimes we just protect ourselves. And what do? Although you have applied, my sister said she had applied for the naturalization, she's done the form and etc. These days, you don't even send the passport. You don't even send the passport. You scan everything. So you have your passport with you. You have everything, all your documents, you have it with you physically because you only have to scan and send to them. It is also very, very nice to just protect yourself by doing the settled status online. You don't pay anything anyway. So why don't we just do that and protect ourselves? Although you are okay by doing the naturalization, but sometimes some of the employers, excuse me to say, they are a bit itchy up there. So they tell you because you haven't applied, it's permanent residence card, you have to stop work, blah, 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 blah. So I would say just to be on the safer side, just apply for the settled status. Just put it in. Once it is done, you have a reference number. You can carry on with the indefinite, the British citizenship application. So that goes to my sister who asked the other question as well.
All right. Thank you very much. I will let the person know.
No problem. Thank you, sir.
Thank you.
Yeah.
All right. Thanks very much. Thank you so much. I think the sister you mentioned just briefly, I think she has a follow-up question.
That's okay.
Yes.
Oh, sorry, it's me again. I've just remembered. You know, when I was doing my application for the naturalization, they were asking me, you know, the number of times that I've stayed outside of the UK.
Yeah.
I remember when I was doing my permanency, you know, the settlement.
Yeah.
I answered similar questions, but because I go to Ghana and other places a lot, so I couldn't remember. I could remember few up to 2016, 2015, but you know the rest down, I just couldn't remember. But when I read the condition, it says in the last 5 years. So I was thinking probably I'm covered because they would have that details from when I did the, you know, the permanency residency. Because, but it's, you know, when you go to Ghana, when you leave, they don't stamp in. It's when you are coming. That's when they stamp in. So if you cannot retrieve your, you know, ticket, you know, the plane ticket is so difficult to work out. And it's over a long period. So I was going back to 2010 and I couldn't remember everything. So I think I did up to 2015. So I don't know whether they would, disqualify me for not providing all the details.
My sister, you are safe and secure. Look, under Section 6, Schedule 1-2 of the British Nationality Act, that is where you are covered. It talks about the residential requirement, and they look at just the last 5 years. Now, so if you yourself going to go and tell them all kinds, so what you can remember is what you give. Of course, if you cannot retrieve all the dates, you can have a rough estimate. I don't think they're going to go to the airport and they would not check all of these things. Just provide what you have within the last 5 years. You are covered. You will be given your thing, so don't you stress yourself about it.
Okay. Oh, thank you very much. The other thing is the character, the good character requirements.
Yes.
Online, they've, listed all the things, including driving offenses, everything is there. And then they'll ask you whether you've got any criminal convictions. And, it doesn't, when you do it, usually before, when it used to be the paper version, you have all the details, but online, it sums up. And then once you tick no, it doesn't give you the next page to go on. It just, because, they would be asking you a series of questions, whether you've got penalties, you've got any criminal offenses, driving, points, whatever, whether you've done anything, that shouldn't warrant you getting your naturalization. It gives you just one. So when you tick no, it doesn't, it says it will give you the other option to go on to the next page, but it doesn't.
What do you want to take?
Sometimes, on the paper version, because you are a lawyer, you always deal with, these applications. Before, but online, it just gives you that stamp. And once you take yes or no, it doesn't give you it doesn't explain it as the guidance does.
The guidance is more of a detailed explanation as to all the things that cover the good character. Like you said, bankruptcy, criminal record, court, whether even your child has been is on this on a register of antisocial behavior, and all kinds of things, overstaying and all the other stuff. It all covers the good character requirement. Now, as long as you take no, because you don't fall within any of those ones, there is no problem. It is when you take yes, that is where it will then give you another box to provide further information. But if it is no, it's assumed that all that is captioned under the good character requirement, you are free from it. So I think it's just a summary. If there is any more information, or if they themselves go and make any findings and they think that there is a further question to ask, they will always get back to you. And then you can.
You've made it really, really clear. Thank you very much. Because I had points in 2007, but that point is just gone off my license. So I wanted to explain that I had penalties before, but it's not applicable. It's not relevant now. It's not, showing on mine. It goes off after 5 years. That's what they told me. So I ticked no with the assumption that it will give me the next page to explain myself, but there wasn't any explanation box. So I just left it.
Yes. Now, with the, again, the good character, it talks about, it's a long list of things. And the word is character. So character is not something you have just done once, but something you keep doing. Is part and parcel of your life. So where you got the point the first time, another time you got the point again, the next, it's like that is your life, that is your character. But if it is a one-off and the time is past, it is not character per se. So that is what it is. So you shouldn't worry about it too much.
Thank you, my brother. You've answered all my questions. Thank you. I was just worried about it. Thank you very much.
Welcome. Chairman, we can't hear you.
Sorry. Thank you very much. Thank you for that. I was just rattling away. Yeah, thank you very much. I think we've gone past the hour mark at the moment, but I've got one more question to go. Someone has asked a question in a text. what are the time limits between two applications for different purposes? That is 2 different applications to the Home Office.
Time limit, it means when the application goes to the Home Office, or?
Yeah, maybe if one application goes in, maybe you want to make another application. Is there any time? Yeah.
So if one goes and it's refused,
Yeah.
and you want
yeah.
there is no time. If
okay.
as long as there is a change in circumstance, for example, you made an application, as you get those documents, you can always make a fresh application. You don't have to wait for a month. But the longer you are waiting, it's very likely you become an overstayer within a certain period. So as soon as you get the documentations, you quickly make another application. With EU application, there is no time limit. Anytime you can always make an application.
Okay.
With under the immigration rules, in that case, there are normally you have the right to appeal. So I would always advise that if you have the right to appeal, because that makes your visa continuous. Even though it has expired in the passport, once you appeal, automatically it continues until it is. That is what we call Section 3C of the Immigration Act of 1971, until a decision is made by the court.
Okay. All right. Thank you very much. Thank you very much, Lawyer Wisdom. We cannot thank you enough for this free legal advice for a full 1 hour. Only God knows why you would have been earning had it been in your office, but we are most grateful to you. And then I think the whole community is quite happy with your contributions. That is why, once again, I have advertised his contact number on the chat. So whoever wants to make contact after this, you are please welcome to do so. And if you find any difficulties, just get hold of me or get hold of SARKI, and then we'll make sure you get in touch with Lawyer Wisdom for your legal needs. I know, Safwa, you might have a follow-up question, but we're just wrapping up at this point in time because we've gone past the hour mark at the moment. But you've got Lawyer Wisdom's contact number on the chat box. You can make contact after the program today. So it is just a should I say, vote of thanks, which is a bit informal. Say thank you very much for your time.
Next month, when I think a month's time, we should be having it again. I intend at the options that you can, if you have a child in Ghana, your brother's child, your sister's child, your big brother, your small brother. Yes, I want to look at the options that you can bring them here. Maybe some are through adoption and etc. etc. I'll touch on a few of those things so that at least we have some knowledge as to how to help the family to come here genuinely.
Okay, all right. So thank you very much for that offer again. Just to tell everyone, we'll try to hold at least one session at the end of every month. We're looking at the last Sundays of every month. So whichever date it falls on, then we'll be privileged to have you again. Thank you.
I think last month we didn't have it, right?
Yeah, because you were in
America by then.
I was chilling. I was chilling.
Yeah, you needed it. You needed it. That was good. Yeah.
All right. Thank you so much.
Right. Thanks. All right. Have a lovely evening. Thanks.
All right. Thank you very much, lawyer.
You're welcome.
We'll talk, inshallah.
Okay. God bless.
All right. Bye.
Bye. So thank you very much to all listeners. I'm really impressed with the number of people that have logged in today. We're really grateful for your time, and we hope you'll make time to join us in our subsequent programs. We plan to get Lawyer Wisdom back on Zoom at least once every month. This is free legal advice for 1 hour. So you are all please welcome to contribute.
Just tell them it's every last Sunday of the month.
Yeah, last Sunday of every month. So, and as time goes on, we will continue to have virtual programs, but the advert will come out in due course so that you get to know the dates and the time of other programs that we are planning to hold. So we've come to the end of today's session. Thank you very much for your time. Have a lovely evening till we meet, we regroup again. Bye.
Bye.
Bye. Bye.
Thank you very much. Thank
You're
you.
welcome. You're welcome.
Thank you.